Justice Sankaran, who is going to take us through the nuances of Section 5 and Section 14 of the Limitation Act. And as Vikas has put it, all of us know what is Section 5 in detail, but regarding Section 14, many of us are unaware. Section 5 deals with the continuation of delay, which is nothing but the extension of the prescribed period in certain cases. And Section 14 deals with the exclusion of time of proceeding, which is bona fide in a court without jurisdiction. And it consists of two limbs also. And the Supreme Court, I think it was in Kumaradasan Nayar's judgment, where it was said that Section 14, that was regarding the first limb of Section 14, that was applicable only in the suits in your definition of the suit which is contained in Section 2 of the Limitation Act. But the principle thereof that could be applied for the purpose of continuation of delay in filing even a revision application in terms of Section 5. And the main objective that the Limitation Act itself, it serves as is to primarily provide a bar upon the time limit within which the aggrieved party he can institute a suit or an application or an appeal in the court. And if the legislation upon limitation is not enacted, then it would have led to some an unconditional or a never-ending litigation procedure, as no party would be concerned to refer a timely litigation, and the party, you would find his cause of action not being executed for a long time. And now today we have two sections which prima facie on a primary blush would appear more or less similar, but Section 5 and Section 14, they are not mutually exclusive, and the principles of Section 14, to my limited knowledge, it may be used to constitute a sufficient cause under Section 5. Now over to you, Justice Sankaran.
Thank you, Mr. Prem. Thank you, Mr. Vikas.
So only one facet, while we will be talking about Section 5 and 14, I'm sorry that while we were discussing about the webinar, we didn't take things forward. Like the Arbitration Act, etc., where the you cannot get the continuation if some PEEP today could be taken up, or we will take it on some other session, where there's no provision to condone the delay.
That is, we'll deal with separately.
Okay, it's fine.
Deal with separately.
Yeah, because I felt that is also an important fact. Normally, people feel that this delay can be condoned by moving an application. Over to you, sir.
Yes. Now, dear friends, today we have to deal with Section 5 and 14. Section 5, all of us know that is a provision for extension of time, which is popularly known as condonation of delay. The exact word used in the section is extension of the prescribed period. I have told you the period of limitation and prescribed period are different. Section 2J of the Limitation Act defines the period of limitation as the period provided in the schedule, and the prescribed period, the period of limitation computed in accordance with the provisions of the Act. Now, this is extension of the prescribed period. Extension of prescribed period in certain cases. Let us see what Section 5 says. And in the earlier session also I said that the Limitation Act applies to suits, appeals, and applications. Other application and order suit, appeals, and applications. Sorry, Section 5 does not include a suit. Let us see the wording of Section 5. Any appeal or any application other than an application under any of the provisions of Order 21 of the Code of Civil Procedure may be admitted after the prescribed period if the appellant or the applicant satisfies the court that he had sufficient cause for not preferring the appeal or making the application within such period. Explanation is also there. The fact that the appellant or applicant was misled by an order, practice, or judgment of the High Court in ascertaining or computing the prescribed period may be a sufficient cause within the meaning of the section. So delay can be condoned on sufficient cause. In what cases it will apply? It will apply only to appeals and applications other than an application under Order 21 of the Code of Civil Procedure. Order 21, we know that it relates to execution. So far as suits and execution petitions are concerned, Section 5 is out of place. Section 5 cannot be applied to suits and execution petitions. Now, if a suit is to be filed today, the person who comes to the court with all papers ready, he has to file the suit today. While coming to the court, he met with an accident. He was in the hospital for 1 week. He is discharged from the hospital. Immediately rushes to the court and files the suit. There is a delay of 1 week. Question is whether the delay can be controlled. The answer is no. There is no question of extension of the period for filing a suit. There are other provisions in the Limitation Act where a fresh period is available, extension is available, exclusion is available, all those things are available. But for condoning the delay in filing a suit, there is no provision. It may appear to be harsh, but it is a fact that the court lacks power to condone delay. Section 15, 14 so operates in a different field, but as Prem pointed out, they are not mutually exclusive. And we will come to Section 14 later. Now, in the matter of condonation of delay in filing an appeal, the court can condone delay provided there are sufficient reasons. It is not the extent of delay that really matters. It is the reason of causing the delay, whether there is sufficient cause for the delay, preferring the appeal or application. Whether the court is satisfied with your explanation. If there is sufficient ground, even if the delay is for months together or years together, in appropriate cases, the court has power to condone delay. Court must be satisfied, satisfies the court. The order passed by the court must record that satisfaction. I am satisfied that there are sufficient grounds as stated by the petitioner. It is not the extent of delay, I said. Even if there is a delay of 1 month in filing the appeal, it is likely to be dismissed. But even if the delay is 1 year, it is likely to be condoned, provided it depends on the reasons. Sufficient cause, sufficiency or otherwise of the cause. Now, the courts were taking a strict view in the matter of condonation of delay. Up till 1987, I may say. When I started practice, to get an appeal admitted to delay condonation for 30 days or 20 days was very difficult. Even if it is 15 days delay, the courts insisted on explaining each day's delay. Each day's delay. That was the practice. But a complete change occurred by a decision of the Supreme Court. That is, in 1987 Supreme Court, 1353, where the court said 7 tests were laid down, which was not hitherto being adhered to, followed, or prescribed by the courts while the matter of condoning delay. Let us see what the principles are. I will read out. 1. Ordinarily, A litigant does not stand to benefit by lodging an appeal late. This is in paragraph 3 or 4 of that judgment. 2. Refusing to condone delay can result in a meritorious matter being thrown out at the very threshold. 3. If the delay is condoned, the highest that can happen is that the case would be decided on the merits. 4. The principle that every day's delay should be condoned. A pragmatic and not a pedantic approach should be made by the court. That was the test. Have you explained every day's delay? Or the argument of the respondent will be every day's delay is not explained. Some delay is explained, but this date, 15th or 16th, that date, the delay of that date is not explained. So even a non-explanation of a single day's delay may sometimes be fatal to the maintainability of the application. The principle that every day's delay should be condoned, a pragmatic and not a pedantic approach should be made by the court. 5. When substantial justice and technical considerations are pitted against each other, the course of substantial justice deserves to be preferred, for the other side cannot claim to have vested right in injustice being done because of a non-deliberate delay. Next, 6. There is no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. A litigant does not stand to benefit by resorting to delay. In fact, he runs a serious risk. It must be grasped. 7. It must be grasped that judiciary is respected, not on account of its power to legalize injustice on technical grounds, but because it is capable of removing injustice and is expected to do so. This decision made a complete change to the scenario then existed. And in various decisions of Supreme Court, this 87 Supreme Court was followed. 87 Supreme Court was followed, applied, and there is no other decision which departs from it. Of course, there are decisions which say that the reasons must be stated, it must be proved, and all those things. But at the same time, the principles which are set out in 1987 Supreme Court are being followed in other decisions of Supreme Court till now. Now we will also see some of the decisions, 5 or 6 decisions, very important decisions. Nothing more than that. I am citing only Supreme Court judgments because advocates from various states are there. Please note another decision. 2010 5 SEC. 2010 5 SEC. I did not mention the citation, the name of the case, AER 1987 Supreme Court 1353. Name of the case is Collector Land Acquisition Anandanag. Collector Land Acquisition Anandanag versus Mosamad Katiji and others. Now, next decision is 2010 5 SEC 459. Name of the case, Oriental Aroma Chemical Industries Limited versus Gujarat Industrial Development Corporation and another. This 87 was followed. Principles are set out. Next, 2019 10 SEC 408. 408. 3 judges, State of Manipur and others versus Koting, Koting, Lamkang, Lamkang. Another decision of the Supreme Court, AIR 2018 2018 Supreme Court 807 Bengal Chemists and Druggist Association versus Kalyan Chowdhury. There the Supreme Court dealt with certain other principle where a period of limitation is fixed, peremptory or mandatory language. And dealing with that question, the Supreme Court answered in that case, peremptory or mandatory language providing for statutory period of limitation, including a grace period, which may be provided on showing of sufficient cause. Words such as not exceeding or but not thereafter. The Supreme Court held that they are equivalent in clearly indicating that the limitation period can be extended no further. There are certain statutes, for example, NIA Act, Section 21 appeal. Certain period is fixed and an extension up to a particular limit is fixed. Going by the decisions of Supreme Court, when such peremptory fixing, then there is no question of any extension. Depending upon the nature of the statute, the purpose for which it is made, and the nature of the proceedings, all these interpretations arise. And next, and in this context, I may say that in Order 8 Rule 1 CPC, written statement, by the 1999 amendment, a period of 30 days was fixed. In 2002 amendment, a proviso was added that it can be extended up to 90 days. The Supreme Court in Salem Advocate Association case held that even after the expiry of 90 days, the period can be extended because the Supreme Court interpreted the scope and ambit of Rule 10 of Order 8 along with Order 8 Rule 1 and said that a harmonious construction is required. And it was held that even though the words used are that up to 90 days, but the consequences are not mentioned. On the other hand, Rule 10 provides for the court's power, and therefore, in these circumstances, even after 90 days, the court can accept a written statement condoning the delay. Next decision is AER 1988 Supreme Court. AER 1988 Supreme Court. 897. Basavalingappa versus Special Land Acquisition Officer. The expression sufficient cause in Section 5 must receive a liberal construction so as to advance substantial justice. And generally, delays in preferring appeals are required to be condoned in the interest of justice, where no gross negligence or deliberate inaction or lack of bona fides is imputable to the party seeking for condonation of delay. What is sufficient cause is explained. Unrealistic interpretations must be excluded from consideration. And in the matter of functioning of government, the Supreme Court decision emphasizes government decisions are proverbially slow and compared, as they are by considerable degree of procedural red tape in the process of their making. It would perhaps be unfair and unrealistic to put government and private parties on the same footing in all respects in such matters. Implicit in the very nature of governmental functioning, there is procedural delay incidental to the decision-making process. Law is the same to all, to a private party or to the government. But in the matter of exercising the discretion, it is pointed out by the Supreme Court that a private party may decide to file an appeal, he may implement it within time, or even if there is delay, a few days delay. But insofar as the governmental action is concerned, it requires from traveling from one desk to another, decisions to be taken at various points by the various departments, and red tapeism is the hallmark. And all those things are realistic, are to be realistically considered by the court, is what the Supreme Court says. That is the decision in Basavalingappa, AER 1988, Supreme Court 897. Next is AER 1996, Supreme Court 1623. 1623, State of Haryana versus Chandramani and others. Chandramani and others. In view of the fact that the government is an impersonal machinery and the inherited bureaucratic methodology, decisions are taken at slow pace. Certain amount of latitude is not impermissible in such cases. If the appeals brought by the state are lost for such a default, it is the public interest that suffers. The expression sufficient cause should be considered with pragmatism in justice-oriented approach, rather than the technical detection of sufficient cause for explaining everyday thing. This is what the Supreme Court said. Chandramani's case. Next is ILR. It is a Kerala decision. Of course, it was rendered by me. It is not because I have rendered it, I am citing. There are several Kerala decisions, more than that of Supreme Court, various decisions which are very relevant on the point. But since those Kerala decisions, corresponding AER citation is not available, I am not citing those decisions. ILR 2007 1 Kerala 550. 550. It is reported in Kerala Law Times 2007 1 KLT 673. Why I cited this is delay in filing an appeal. There occurs delay in various matters. In the matter of setting aside abatement, which occurs under Order 22 of the Code of Civil Procedure, there also, under Article 120 and 121 of the Limitation Act, the period of limitation for impleading is provided as 90 days. Article 121, to set aside the abatement, it is 60 days. So after 90 days, the suit will abate or appeal will abate, whatever it is. 120. 121, setting aside abatement, another 60 days from 90 days. Court can set aside the abatement. And that takes us to 150 days. After 150 days, what will happen? If the plaintiff dies, or let us take it, the defendant dies, or the respondent in an appeal dies, the appellant has to take steps to implead the legal representatives of the defendant or the respondent, as the case may be. That has to be done in 90 days. On expiry of 90 days, the suit or appeal will abate. But it can be, abatement can be set aside if an application is made within another 60 days. If 90 plus 60, 150 days expire, application for impleading and other applications are filed on the 200th day, what will happen? There is delay. Delay of how much? Is it 200 days or 50 days or 110 days? Is the question. Delay will be 50 days. The principles are explained in that decision. Name of the case is Sankaran and others versus Devagi Amma and others. Sankaran and others versus Devagi Amma and others. There, it is also held that in the matter of condonation of delay in filing an appeal is quite different from the matter of condoning delay in filing the application to set aside the abatement. Because in the latter case, there is already an appeal pending. The party is before court. And in the other case, filing an appeal, he has not approached the court. So the delay in filing an appeal and the delay in making the application for impleadings and setting aside abatement, there is slight difference. In this latter case, that is the matter of condoning the delay in setting aside the abatement, the court will be more liberal than the other thing. It is also held. Next is 2012-5 SEC 157. Name of the case, Maniben Devraj Shah. Maniben Devraj Shah versus Municipal Corporation of Brihan, Mumbai. An appeal by the Municipal Corporation. Delay of 7 years and 108 days. 7 years and 108 days. And the ground made out is that misplacement of necessary papers. The question was whether the delay can be condoned. Supreme Court held that no premium can be given for a total lethargy or utter negligence on the part of officers of the state and or its agencies and instrumentalities. Applications filed them for condonation of delay cannot be allowed as a matter of course by accepting the plea that dismissal of the matter on the ground of bar of limitation will cause injury to public interest. In the other decision cited by me, the Supreme Court said that public interest will suffer. It is true, but though it is public interest, matter relates to public interest. This lethargy, total lethargy, or utter negligence, that is not a ground to condone the long delay. Next decision is a 2016 Supreme Court 3006. 3006. Name of the case, State of Jammu and Kashmir versus R.K. Jalpuri, ZALPURI, and others. That is an application for condonation of delay. Writ petition was filed, challenging an order of dismissal from service, filed after a delay of 5 years. The employee was dismissed from service in the year 1999, but he chose to avail the remedy. He chose not to avail the departmental remedy. He woke up from his slumber to knock at the doors of the High Court after a lapse of 5 years. The staleness of the claim remained stale, and it could not have been allowed to rise like a phoenix by the writ court. So writ petition, generally we will say that the period of 90 days is the reasonable period and all those things. But there is no petition for condonation of delay, etc. Court is exercising its jurisdiction, but that is not a ground to condone or disregard this much lapse on the part of the litigant. Next decision is 2002 3 SEC 195. Ramnath Sao, SAO, alias Ramnath Sahu and others versus Govardhan Sahu and others. That is sufficient cause setting aside abatement, condonation of delay, liberal interpretation should be made than the case of condonation of delay in filing an appeal, etc. That principle has been set out. Paragraph 2 13 and 14. Next is 1996 2 SCC 568. 568. '96 2 SCC 568. 813. 568. 568. I'm sorry. Setting aside abatement, that theory. 96 2 SCC 568, State of MP versus SS Akolkar, AKOLKAR. Now, when you read the commentaries on Section 5 of the Limitation Act, you will see thousands of decisions, thousands and thousands of decisions. I have cited only very few, because the principles, just to mention the principles and also the different situations it may arise and all those things. Now let us go to Section 40. 14 is to some extent difficult, particularly the last portion of it. 14. Exclusion of time of proceeding bona fide in court without jurisdiction. Subsection 3 is to a little bit difficult. 1 and 2 not so difficult. Let us read the particular provision because the words are important. Words are important. 1. In computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding. It does not say suit. So for the purpose of computing the period of limitation for any suit, the time during which the plaintiff has been prosecuting with due diligence another civil proceeding, whether in a court of the first instance or of appeal or revision, against the defendant shall be excluded where the proceeding relates to the same matter in issue. Where the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which from defect of jurisdiction or other cause of a like nature is unable to entertain it. What is the meaning of this? There is a civil proceeding before a court, and that court could not entertain it because of defect of jurisdiction or other cause of a like nature. Thereafter, a regular suit is filed before the court, and it is naturally sometimes beyond time. What will happen to the time spent by the party in prosecuting the case in another court? Whether it can be excluded. If it is a suit, there is no question of condonation of delay or extension of period under Section 5. Section 5 cannot be applied at all. But the period during which he was prosecuting with the due diligence another civil proceeding, if that period can be excluded, then if the suit is within time, the court can exclude that period during which this litigant was prosecuting with due diligence another proceeding in respect to the same subject matter, same matter in issue, in a court which because of defect of jurisdiction or other cause of a like nature could not entertain. What is defect of jurisdiction or other cause of a like nature? Supreme Court has said that defective jurisdiction or other cause of a like nature should be read adjustum generis with defective jurisdiction. There is some defect, court could not entertain it. Therefore, the suitor fails because of lack of jurisdiction or defective jurisdiction or jurisdictional aspect. And he institutes a suit in the regular court, which has jurisdiction. But if it is beyond time and the period during which he was prosecuting the defective proceedings before a wrong court, then the suit is within time. The delay, that it is not question of condoning the delay, the exclusion of the period during which he was prosecuting with due diligence another civil proceeding in respect to the same matter in issue in a court which, because of defective jurisdiction or other cause of a like nature, could not entertain that. That is subsection 1. Let us see subsection 2. In computing the period of limitation for any application, subsection 1 is for a suit and subsection 2 relates to application. The time during which the applicant has been prosecuting with due diligence another civil proceeding, same wording as in subsection 1. Whether in a court of the first instance or of appeal or revision, same thing as in subsection 1. Against the same party for the same relief shall be excluded. Subsection 1, it is not the same relief, relates to the same matter in issue. That is a difference. Same matter in issue. The suit as well as the former proceedings in a wrong court was in respect to the same matter in issue. Whereas in the case of an application, not a suit, that is subsection 2 relates to computation of the period of limitation for an application, the time during which the applicant has been prosecuting with due faith, with the due diligence, another civil proceeding in a wrong court for the same relief. That period shall be excluded where such proceeding is prosecuted in good faith in a court, which because of defect of jurisdiction or other cause of a like nature not entertained. There also the reason is defect of jurisdiction or other cause of a like nature. There also it is proceeding. And instead of suit, it is an application. Subsection 1 relates to suits, and to apply section 14, it must be in respect of the same matter in issue, the suit as well as the proceeding. Whereas in the case of an application for exclusion of that period, it is more stringent. The former proceeding must be for the same relief as in the case of an application filed before the regular court subsequently. This is the difference. One is same relief, the other is same matter in issue. Rest is the same. Then you have to read along with this explanation. For the purpose of this section, we will come to 3 later. For the purpose of this section, in excluding the time during which the former civil proceeding was pending, the day on which that proceeding was instituted, and the day on which it ended shall both be counted. B. A plaintiff or an applicant resisting an appeal shall be deemed to be prosecuting a proceeding. What is the meaning of this? A plaintiff or an applicant resisting an appeal shall be deemed to be prosecuting a proceeding. That is a person prosecuting a proceeding in a wrong court because of defective jurisdiction or other cause of a like nature, the court could not entertain it. And it was a bona fide one, it was being prosecuted with due diligence. That period will be excluded in the case of a suit under subsection 1 and in the case of an application under subsection 2. Now, what is this? A plaintiff or an applicant resisting an appeal shall be deemed to be prosecuting a proceeding. What is the meaning of this? I will give an example to clarify it. See, A files a suit against B. B says the court has no jurisdiction. the court in which the proceeding is initiated has no jurisdiction, suit or proceeding, whatever it is, has no jurisdiction. That court says that it has jurisdiction. There is no defect of jurisdiction or other cause of a like nature. And the matter is going to be decided. Whether at that stage or after the decision is rendered, this question of jurisdiction is challenged in appeal or revision as the case may be, or in original petition under Article 227, whatever it is. Whether at the initial stage itself it is challenged or after the disposal of the proceeding it is challenged. But this question is under challenge. So the trial court said that there is no defect of jurisdiction. And the contention of the respondent is out of place. It is not, it is without any substance. That means the plaintiff succeeded in respect of that point. Before the appellate court, it does not agree with the trial. It says that there is defect of jurisdiction. And it is held that the suit or proceeding before that court is not maintainable. What happens? That suit fails. Suit fails because of the decision of the appellate. What will happen during the time in which he was prosecuting the suit? During the time in which he was prosecuting, he was defending the appeal or revision. That is what he said. Plaintiff or an applicant resisting an appeal shall be deemed to be prosecuting a proceeding. So, the plaintiff or applicant, in the case where it was held that the trial court held that it has jurisdiction, but the appellate court says otherwise, he was prosecuting the suit and he was prosecuting the appeal. So, the time during which shall be deemed to be prosecuting the appeal, the time during which he was resisting an appeal shall be deemed to be prosecuting. It need not be prosecuting. The word prosecuting need not refer to his being a plaintiff or petitioner, applicant. Even as a respondent, he may prosecute, because without prosecuting, he cannot substantiate his contention that the suit is maintainable, there is no defect of jurisdiction. He succeeded in the trial court with respect to the jurisdictional aspect, but he did not succeed before the appellate court. The period during which he was prosecuting as a respondent, the appeal, he was defending the appeal, that period also will be counted as a period during which he was prosecuting with the due diligence. The time during which he was prosecuting the original proceeding in the trial court, plus the period during which he was resisting the appeal, that both will be excluded for the purpose of subsection 1 or subsection 2 as the case may be. Now we go to 3. To understand subsection 3, we have to have CPC also with us. Order 23. Order 23 CPC. Now, let us read subsection 3 first. Notwithstanding anything contained in Rule 2 of Order 23 of the Code of Civil Procedure, the provisions of subsection 1 shall apply. Subsection 1 of section 14 shall apply. In relation to a fresh suit instituted on permission granted by the court under Rule 1 of that order means Order 23, where such permission is granted on the ground that the first suit must fail by reason of a defective jurisdiction of the court or other cause of a like nature. On a simple reading of subsection 3, see, it is very difficult to understand. So we have to see what is Order 23, Rule 1.3. Order 23, Rule 1 provides for abandonment of suit and withdrawal of suits. Abandonment the plaintiff can have at any time. Withdrawal also he can do in 2 ways. 1, without the permission of the court, and 2, with the permission of the court. If no permission is granted by the court, no permission is applied for, no permission is granted, he cannot file another suit in respect of the same subject matter. Whereas if permission is granted, he can file another suit. Withdrawal of suit can be for reasons mentioned in subsection 3 of subrule 3 of rule 1, which says that where the court is satisfied that a suit must fail by reason of some formal defect or that there are sufficient grounds. I am reading order 23, rule 1, subsection 3. The court may permit, and if permission is granted, with the liberty to institute a fresh suit in respect of the same subject matter or part of the claim. And where it is provided where in subrule 4 that if a plaintiff abandons the suit or withdraws from the suit without permission, he shall be precluded from instituting a fresh suit in respect of such subject matter or part of the claim. This is the disqualification which a person suffers on account of withdrawal of suit without permission of the court. So with the permission of the court, it is withdrawn and another suit is instituted immediately. That is not, permission was granted by the court is no guarantee for the period of limitation. That is what is provided in rule 2 of order 20. Let us read rule 2. In any fresh suit instituted on permission granted under the last preceding rule, the plaintiff shall be bound by law of limitation in the same manner as if the first suit has not been instituted. So I will summarize it. A suit is filed. Withdrawal of that suit becomes necessary for any of the reasons mentioned in subrule 3 of rule 1. Because of some formal defect, it may fail or there are sufficient grounds. Sometimes a plaint may be amended 10 times. It looks so clumsy. Reliefs are changed, court fee changed, valuation changed, and so many stitching. And therefore, the plaintiff may say, all right, I may be permitted to withdraw this suit, and I shall file a fresh suit. If it is within the period of limitation, no harm. Permission is granted, if it is. If it is beyond limitation, that the court granted permission is no ground to institute a suit belated. Fresh suit will be barred by limitation, means gone. Withdrawal from the suit and institution of a fresh suit is not a continuation of the earlier suit. That is well settled. And therefore, when you withdraw the suit, be very careful to see that a suit filed thereafter with the permission of the court would be within time. Because rule 2 of order 23 says that if a suit is withdrawn, it is subject to the limitation. Permission. The plaintiff shall be bound by the law of limitation, the same manner how it is computed as if the first suit has not been instituted. The court will look into the second suit. Is it within time? It is not within time. No matter whether permission was granted, no matter whether an earlier suit was there, all these are out of question. Court will not look into. As if the first suit is not there, limitation will be computed for the purpose of the second suit, a fresh suit instituted on permission of the court. This is the rule. Now let us read subrule 3. Now let us read subrule 3 again. Notwithstanding anything contained in rule 2 of order 23. Order 23 rule 2 says that limitation is not saved. The provisions of subsection 1 shall apply. Provisions of subsection 1 of section 14, which provides for exclusion of the period, shall apply in relation to a fresh suit instituted on permission granted by the court under rule 1 of order 23 of that order, means order 23, where such permission is granted on the ground that the first suit must fail by reason of a defect in the jurisdiction of the court or other cause of a like nature. Withdrawal can be on many grounds. But if that ground relates to defect of jurisdiction or other cause of a like nature, as is mentioned in subrule 1 or subrule 2, subsection 1 or subsection 2, then Notwithstanding anything contained in Order 23 Rule 2, the period of limitation the period of limitation will be computed after excluding the period during which the first proceeding was pending and that was withdrawn with permission and with leave to institute a fresh suit, and that was on the ground of defect of jurisdiction or other cause of a like nature. So from the various grounds which are available under Order 23 Rule 1.3, this ground is carved out and it is made part of Section 14. So to that extent, this is an exception to Rule 2 of Order 23. So notwithstanding anything contained in Order 23 Rule 2 is the general rule that if you institute a suit, withdraw it with permission, institute a fresh suit. Fresh suit, the period of limitation will be computed as if you have not instituted the earlier suit at all. The court will look into what is the date of institution of this suit. Now, that withdrawal can be on various grounds. But if that withdrawal was on the ground of defect of jurisdiction or other cause of a like nature, then notwithstanding that Rule 2 of Order 23 says that the period of limitation will not be saved, it will be saved if it relates to a matter where because of defect of jurisdiction or other cause of a like nature, the plaintiff could not continue that suit or application as the case may be, and it was permitted to be withdrawn on that ground specifically. This is what is subsection 3. So this is an exception to Rule 2 of Order 23. Now let us see some of the decisions of Supreme within the time permitted. Now it is 20 over, therefore we'll go fast. Section 14 decisions. So that a few of the decisions I will mention, which will help you. Yes, now 2015 7 SCC 58. 2015 7 SCC 58. MP Steel Corporation versus Commission of Central Excise. Justice Rohington Nariman rendered that judgment. That is a case where it was held, I cited it earlier, where it was held that the Limitation Act applies to courts and not to tribunals and quasi-judicial authorities. That is, that point is reiterated. All the relevant decisions on that point have been considered by the Supreme Court, and this was also held, Section 14, even though the provisions of Section 14 applies to only to courts proper, that is, courts as understood in the strict sense being part of the judicial branch of the state. But principles underlying Section 14, which advance cause of justice, apply to appeals filed before quasi-judicial tribunal, such as that under the Customs Act, 128 of the Customs Act. Is not a complete code. Customs Act is not a complete. So, in MP Steel, it is held that Limitation Act applies to courts. Section 14 provides for exclusion in certain cases. Though it is not a court, the principle of exclusion will apply to statutory tribunals as well. It is not Section 14 as such. The principle will apply. That is what is. Then 2018 7 SCC 169. Consolidated Engineering Enterprises, and another versus Principal Secretary, Irrigation Department. And there you may see paragraph 11, 12, and 14. Paragraph 11 and 12 and 14. While considering the provisions of Section 14 of the Limitation Act, proper approach will have to be adopted and the provisions will have to be interpreted so as to advance the cause of justice rather than abort the proceedings. It will be well to bear in mind that an element of mistake is inherent in the invocation of Section 14. In fact, the section is intended to provide relief against the bar of limitation in cases of mistaken remedy or selection of a wrong forum. On reading section 14 of the Act, it becomes clear that the legislature has enacted the said section to exempt certain period covered. The principle further down, the principle is clearly applicable, not only to case in which the litigant brings his application in the court, but that is a court having no jurisdiction to entertain it, but also where he brings a suit or application in the wrong court in consequence of bona fide mistake of law or defect of procedure. Having regard to the intention of the legislature, this court is of the firm opinion that equity underlying section 14 should be applied to its fullest extent, and time taken diligently prosecuting the remedy in a wrong court should be excluded. Now, 2009, 1 SEC, 2009, 1 SEC, 786. 786. Name of the case, Messrs. Shakti Tubes Limited versus State of Bihar and others. A writ petition was filed and a suit was later filed. Appellate court declined to exclude the time spent pursuing the writ petition. The question was whether the time spent in proceeding with the writ petition, which was defective because of jurisdiction aspect, that can be excluded. Discussion in paragraph 22, 23, 24, 25, 26. And provisions of 14 of the Limitation Act have been held to be applicable even in a proceeding arising under section 34 of the Arbitration Conciliation. That was another case decided by the Supreme Court, which is referred to here. It is well settled that another decision was referred to. All questions of limitation by the and courts cannot travel beyond the terms of the words used. Yes. Next is AER 1997, Kerala. A Kerala decision I am compelled to mention, 361. By Justice Balasubramanian, who retired as a judge of the Supreme Court. Name of the case, Rajaratna Naikan, Rajaratna Naikan, Naikka, versus Parameshwara Kurup. AER, it is not reported. It is in KLT also, it is reported. 1997 1 KLT 777. So an application under Order 21 Rule 90 was filed. It was dismissed. Later, an application under Section 47 was filed, CPC. Whether that period can be excluded, whether that application is maintainable, all these questions were considered. Even after dismissal of an application under Rule 90 of Order 21, an application under Section 47 can be made. Very detailed discussion, facts in paragraph 2, then discussion in paragraph 5, 12, 13. I therefore overruled the contention on behalf of the decree holder that the judgmentator, having earlier applied for setting aside the sale under Order 21 Rule 90, is stopped from filing an application under Section 47 of the CPC. Then paragraph 13. The application under Section 47 of the Code was admittedly made out of time. In view of my conclusion that Section 14 of the Limitation Act is not available to the judgmentator to exclude the time spent by him in prosecuting the application, he is not entitled to exclusion. Why it was held? Because it was not for the same relief. The application under Order 21 Rule 90 and the application under Section 47 is not for the same relief, because Section 14(2) of the Limitation Act provides that it must be for the same relief. The former proceeding and the later application or suit should be for the same proceeding. Next is 1997 9 SCC. 1997, 9 SCC, 701. Sundar Das and others versus Gajanan Rao and others. Next is AER 1985 Supreme Court 39. Safar Khan and others versus Board of Revenue. From defect of jurisdiction or other cause of a like nature, what is the meaning of it? The expression cause of a like nature will have to be read ejustem generis with the expression defect of jurisdiction. The expression other cause of a like nature must be so interpreted as to convey something analogous to the preceding words from defect of jurisdiction. The party seeking the benefit of section 14 failed in the earlier proceeding on merits and not on defect of jurisdiction, then section 14 cannot be applied. Next is AER 1985 Supreme Court 1669 Vijay Kumar Rampal and others. Vijay Kumar Rampal and others versus Diwan Devi. 14 of the Limitation Act, see the discussion. Next is 2002 Volume 6 SCC 336. Deena through LRs versus Bharat Singh. Time taken for proceeding with a suit without impleading necessary party cannot be excluded under 14(3) and is a clear case of laches because party pursuing such suit cannot be said to be acting in good faith. The expression as used in means exercise of with due care and attention. Because it is defined, good faith does not include a proceeding taken without due care and attention is section 2 is defined. Next, 2000 volume 5 SCC 355. Corresponding AER citation, AER 2000 Supreme Court 2023. Sarathi versus State Bank of India. What is the meaning of this expression court in section 40? Not only civil court, not means civil court, but also includes any authority or tribunal having the power of a court. It need not be civil court. Section 14 says about court, and in Sarathi's case, it was held in paragraph 15, applying the above principles in the instant case. We are of the opinion that the Deputy Commissioner of Labour Appeals, which was an authority constituted under 41(2) of the Tamil Nadu Shops and Establishments Act, to hear and decide appeal, was a court within the meaning of section 14 of the Limitation Act, and the proceedings pending before him were civil proceedings. Next, 2010-15 SCC 259. New Grameen Milk Cooperative Society Limited. New Grameen Milk Cooperative Society Limited versus General Manager, Delhi Milk Scheme, Government of India. 259. There it is clear that the appellant was under a bona fide wrong impression that it could execute the award directly, being under the impression that the matter was governed by the new law, Arbitration Act. Therefore, the period spent in pursuing the execution proceeding has to be excluded. Further, delay of 1.5 months in filing the application for making the award rule of the court. So, under the unamended, under the old Arbitration Act, the arbitral award had to be made the rule of the court by making an application before the district court. Now, under the present act, the award can be executed as if it is a decree. So he filed an execution petition. It was found that it was defective because the old act will apply. So he had to make an application before the district court to make the award a rule of the an order that award directly cannot be executed. The period during which the execution petition was pending can be excluded. Discussion in paragraph 6, 7, and 8. Then AER 2009 Supreme Court 1333 1333 Kumaradasan Nair versus IR, IC, Sohan and others. This is the decision which Prem pointed out. See paragraph 13, 14 and 15. The provisions of section 5 and 14 of the Limitation Act alike should thus be applied in a broad-based manner when subsection 2 of section 14 of the Limitation Act per se is not applicable. The same would not mean that the principles akin thereto would not be applied. Otherwise, the provisions of section 5 of the Limitation Act would apply. There cannot be any doubt whatsoever that the same would be applicable to case of this nature. Paragraph 14, there cannot furthermore be any doubt whatsoever that having regard to the definition of suit as defined in section 2L of the Limitation Act, a revision application will not answer the said description. But although the provisions of section 14 of the Limitation Act per se are not applicable, in our opinion, the principles thereof would be applicable for the purpose of condonation of delay in filing an appeal or a revision applicable under section 5. Then a discussion in paragraph 15 towards the last of that, when the provisions are meant to apply and in fact found to be applicable to the facts and circumstances case. In our opinion, there is no reason as to why the court will refuse to apply the same only because a wrong provision has been mentioned. In the case of this nature, subsection 2 of section 14 per se may not be applicable, but as indicated here and above, the principle thereof would be applicable for the purpose of condonation of delayed terms of section 5. That is how it applies. It is not mutually exclusive. There is a Kerala decision on that point, 1991, 1 KLT 218. 1991, 1 KLT 218. Samuel Joseph versus Ramachandran Chellayan. Section 5 and 14 are not mutually exclusive. Even in a case where section 14 applies, section 5 is not excluded. Section 5 is not excluded. These are some of the decisions which I intended to mention. Now, I think I have completed with the time with Mr. Vikas. Back to Vikas.
Yes, sir. As usual, logging in was the punctuality, taking the session was more punctualist. This is by Paradish. Sir, to what extent is section 14 applicable to proceedings under the Insolvency and Bankruptcy Code?
That I am not sure. I'm sorry, I cannot give an answer because I have not studied the scope of that act.
Gokuldas Vasu. A decree
now,
holder.
Probably because of the other decision which I cited, though it is not a court, that is the decision by Justice R.V. Ravindran which I mentioned, cited, Supreme Court decision. Even though per se it may not apply, the principles may apply. 2 decisions I cited today on that point. Therefore, please see whether it can be applied to your case. Yes. Whether Prem has got any answer on that question. Please help. Prem is an authority on decisions.
Yeah, I will ask. Okay. I'm just giving him a call. So meanwhile, Gokul Das has written a query. Just examine that. I will ask Prem to come.
Yes.
Prem has not taken the call. Meanwhile, a decree holder files an execution petition after a passage of 17 years. The execution is dismissed for want of prosecution. Now, a year has passed since the dismissal. As decree is valid for 12 years, what is the remedy? Can delay be condoned for restoration of execution petition, or a fresh execution petition has to be filed?
Now the execution petition was filed.
Yeah, no, that was dismissed for non-prosecution.
Execution petition was dismissed for non-prosecution.
But the execution petition took 17 years meanwhile. Now he says that since the fresh execution could have been filed within 12 years. Now whether he has to file an application for seeking restoration by filing an application for condonation.
No, original execution petition was filed within 12 years.
Yes.
That was filed within 12 years. That was dismissed for default.
Yes.
Then now if you file it, it is beyond 12 years. Is it not? Now rule 105 and 106 of order 21 will answer it. 105 and 106, if you read, if the execution petition is posted for hearing and if a party fails to appear, it shall be dismissed for default. And within 30 days, he can make the application. There are some decisions, including a decision which is rendered by me. Ordinary posting of the case, execution petition, and it is dismissed for default, and application for restoration, that 105 and 106 will not apply. If it is posted for hearing, then only that 30 days period will apply. Otherwise, section 151 can be applied. But here, the execution petition was filed within time, but it was dismissed for default. How many days after dismissal for default?
1 year.
1 year. If it is posted for hearing, it cannot be condoned because there is no power to condone delay. 30 days is the period. Under rule 105 and 106 read together, I will just exactly say the wording. Order 21, rule 105 and 106. The court before which an application for any foregoing rules is pending may fix a date for hearing. 106, setting aside. Then 105, 2, where on the day fixed or other day to which the hearing is adjourned, the applicant does not appear when the case is called for hearing, the court may make an order that the application be dismissed. Then that can be restored under rule 106. But a period of limitation is provided, 30 days. Sub-rule 3 of rule 106, an application under sub-rule 1 shall be made within 30 days. The question is whether that delay can be condoned. Because it is an execution petition, section 5 is out of place. Section 5 cannot be applied. Therefore, there are a few decisions, including a decision rendered by me, that if the execution petition is posted for taking steps or for formal posting, not for hearing, and it happens to be dismissed, and an application for restoration is filed beyond 30 days, that rule will not apply, because to apply rule 106, it must have been posted for hearing. Otherwise, in such circumstances, section 151 can be applied. Is the decision. But here 1 year is over. If an execution petition is filed now, it is beyond 12 years. You have to make an application for restoration. And if the execution petition was posted for hearing, he is out.
These days are the provisions of Limitation Act applicable to writ petitions.
Provisions of the Limitation Act as such are not applicable to writ petitions. But the principles may apply in several cases. Limitation Act also, some of the provisions may apply. Section 14 itself, one of the decisions which I mentioned, the period spent during prosecuting in a in the High Court, a writ proceeding can be excluded. Likewise, a suit was being prosecuted, though for writ petition, there is no fixed period of limitation. The High Court can take into account that he was prosecuting in good faith a suit, and therefore it is pending for 1 or 2 years. There was a delay in filing the writ petition. Delay as such is not a question of days or months together, but he came late. That can be taken into account. Therefore, though the Limitation Act as such may not apply to writ proceeding, but the principles may apply as the Supreme Court says.
We have a full bench also of Punjab Haryana High Court. Teja Singh versus UT, 81 PLR page 1, which says broad principles would apply. Like the writ petition cannot be dismissed on the ground of delay. It can be dismissed on the ground of delay and laches.
Yes. Yes.
This is by Chinmay. I have a question. Suit filed for bare injunction. Suit valued at ₹100. After 3 years, written statement is filed, setting up a rival title. Plaintiff amended to add relief of declaration of title. The valuation for the suit increases. The suit, instead of being transferred to the appropriate court having jurisdiction, is returned under Order 7, Rule 10. Immediately, the plaintiff is taken to return and refiled. As to whether a Section 14 can be used in such a case.
Yes. Now, why the court did a wrong? Suit was amended because of the return statement was filed later, and it happened that the suit is to be amended for declaration of title, where the valuation exceeded the pecuniary limits of jurisdiction of that court. The court was not justified in rejecting or returning the plaint. Court should have allowed that application and then returned the plaint, and it can be filed in proper court. Therefore, 14 need not be. Yes, in such case, 14 can be applied. 14 can be applied.
Yes, that 1 hour, 15 minutes are over. So we will wind up. And tomorrow, friends, we will have a session on what is trial and when does it start in the various types of criminal trial. That is by Justice V. Ramkumar. Do stay connected with us tomorrow at 4 p.m. And as usual, sir, you took us to the entire journey of law to understand the Section 5 and Section 14, including their sub-classifications as such. And we are all grateful to you for sharing your knowledge. And it's always a pleasure hearing you.
Thank you.
And as we have already said, that you can like, share, and subscribe to the channel of Justice K.T. Sankaran, where you will get the entire sessions of Civil Procedure Code as well as the Limitation Act. And similarly, on this platform of Beyond Law CLC, we have taken sessions on different aspects. You can also share, like, and subscribe and comment on the channel of Beyond Law CLC for all the sessions so far we have conducted. There are more than 350. Thank you, everyone. Stay safe, stay blessed, and keep on wearing your mask, do vaccination, and maintain social distancing. Thank you. Namaskar.